reasonable doubt. Circumstances only need to be proven by the greater weight of the evidence. You know the scales of justice. One's a little higher than the other. That's what greater weight of the evidence is, okay? Now, the judge may give you a list of circumstances you can consider, but you're not confined to that list. There may be something that came out during the course of the trial. There might be witnesses on behalf of Mr. Wilson. As the state told you, might be something about Mr. Wilson's childhood, him growing up. Could be something about Mr. Wilson's mental health. There could be an unlimited number of things that you could consider individually as a mitigating circumstance. You understand?
I do.
Okay. Well, then you would go back and you would decide whether or not the aggravating factors have outweighed the mitigating factors, or circumstances, excuse me. Now, if the mitigating circumstances outweigh the aggravating factors, then you come back and tell the judge it's light. If the aggravating factors outweigh the mitigating circumstances, then you still have one procedure you have to go through. And that's the most important individual aspect of being a juror, is deciding whether or not you're going to be that person that votes for death or votes for life. And in the state of Florida, it would take 8 jurors to vote for death in order for you to send a recommendation as the jury as a whole to the judge. Okay? Keeping that in mind, let's say there's 7 folks who have voted for death and 4 that have voted for life, and you're the controlling vote. Regardless of what your decision is, are you willing to stick by your decision, not succumb to pressures from any of your other jurors, that your decision is going to be your decision as a juror in this case?
Absolutely.
I don't have any further questions.
Okay.
All right. All right, so remember my earlier instructions.
Yes.
Don't do any research. Don't watch local news media,
Sure.
reading local newspapers. Don't talk to anybody about this case, about any part of it, okay? And then we'll have you come back tomorrow morning, Thursday morning at 9 a.m. You'll report to the jury room on the 2nd floor.
2nd floor tomorrow at 9.
Yes.
Got it.
Thank you.
Thank you.
All right, juror 230.
People swallow, but they don't fall down.
That's right.
All right, please be seated. Are you juror 2? You can be seated.
I am.
Sorry.
Yes.
Are you juror 230?
I am.
All right, then I'll allow the attorneys to begin their inquiry.
Good morning.
Good morning.
I'm Sarah Miller, and this is Andreas Gardner. We're both here on behalf of the state of Florida. Thank you for coming in and for your service here today. Prior to getting here this morning, had you heard or read or seen anything about this case?
Yeah, I saw it on the news last night.
Was that the first time you had seen anything?
No.
You've seen other
Yeah.
coverage?
Yes.
All right. Now, in order for the state to prove the charges beyond a reasonable doubt, we can only do that through evidence that comes into this courtroom. So we plan on calling witnesses, introducing photographs, DNA, other sorts of evidence for the jurors' consideration. And based only on that evidence, is the jury allowed to make their decision as to whether the defendant's guilty or not. Do you believe that you'll be able to set aside anything you may have heard outside of the courtroom through the news and base your verdict solely on what you hear in the courtroom?
I believe so. I was just aware of what had taken place, and that's...
So your mind isn't made up based on what you've seen?
No.
Now, as far as the length of trial, at this point, it'll probably be a couple weeks beyond this week. Do you have anything that would cause extreme hardship for you to sit here on a jury for the next several weeks?
I own my own business, so I already make my own schedule, so I should be able to work around that.
Great, thank you. Now, as far as the death penalty goes, you just heard the judge read a whole list of instructions about the process. It's somewhat of a complicated process, but we'll learn about it as we go through it, as the judge will give further instructions. But we'll start with the guilt phase, where the state will have to prove the charges beyond a reasonable doubt. And then if we prove at least one count of first-degree murder, that's when the jurors will go to the penalty phase and be required to make a recommendation of either life or death. Do you have any personal or moral or religious opposition to the death penalty?
No.
Okay, and I'm going to ask where you fall with your opinion. Some people are at one end of the spectrum where they would say everybody who's charged with first-degree murder should get the death penalty. And then you have other people that would say no one should get the death penalty, regardless of the facts, the circumstances, who's killed, how many people are killed. And then you have people more in the middle that would say there has to be certain times when the death penalty is appropriate. I'd have to hear the facts and circumstances to know how I would decide. Where would you say on that spectrum you fall?
Definitely a supporter of the death penalty. I also believe the appeals process should be expedited
Okay.
for people that are convicted.
Sure.
But I also think that each case has its own set of individual facts that would, that should be taken into consideration.
Sure. So the fact that you're a proponent, that would not get in the way of you being able to listen to this case and to be fair and impartial. Would you agree with that?
Yes.
Now, if at the end of hearing the facts of the case, and the state will have to present aggravating factors, and those aggravating factors are laid out in the statute. The law requires us to allege which factors we're going to be proving, and you'll hear more about those as we get to that penalty phase. If the jury finds the state proves at least one of those factors beyond a reasonable doubt, then you'll also get to consider mitigating circumstances. If the defense wants to present, they don't have to, they can present reasons why their client should not get the death penalty. If after hearing all that, you believe that death is the appropriate recommendation, do you believe you will be able to sign your name and make that recommendation? Yes. And on the flip side, if you feel that it really just didn't meet that level where you would feel death is appropriate, would you be able to turn and to say, you know what, life would be an appropriate sentence?
It all depends on what evidence is presented in a court of law.
Okay, so you haven't made up your mind. You'd make it up after you hear everything.
Correct.
All right. Thank you very much for your time.
Sure.
All right, Mr. Shirley.
Thank you. Good morning. My name is Kevin Shirley. My co-counsel is Lee Hollander. We're pleased to represent Mr. Wilson here today. Let me start with some of the stuff that you told the prosecutor. You said you're definitely a supporter, and you're very affirmative about that. What do you mean by you're definitely a supporter?
If you take a life and you did it on purpose, and yeah, I think eye for an eye. Yeah.
Okay.
Certainly applies.
Well, so do you think that I'm just trying to straighten out my own mind. So if the state shows that he is guilty of premeditated first-degree murder, you think that he should get the death penalty?
Yeah.
Okay. He shouldn't get he shouldn't get life. He should just get death because he's been convicted of premeditated.
Yes.
That's fine. I don't have any further questions.
All right.
Thank you.
Thank you, sir. All right, sir. Okay. Your jury service for the year is complete. You are excused and go about your day. Thank you. All right. Please be seated. Are you juror 476?
Yes, sir.
All right. I'll allow the attorneys to begin their inquiry.
Good morning. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state. Prior to coming in for jury service today, had you heard anything about this case?
No.
And as far as your availability for the next several weeks, do you have any kind of extreme hardship that would make it so that you're unable to serve on this jury?
Well, I have a vacation planned.
And when is that planned?
When?
Yes.
Sunday the 17th,
Okay.
16th. It's a week and a half.
Is it something that you can reschedule, or do you have plane tickets?
I mean, I would lose money, but
Okay.
that's it.
If you were unable to go on your vacation because you were chosen, would you hold that against the state or defense, and would it affect your deliberations?
No.
Moving on to the fact that this is a death penalty case, do you have any personal or moral or religious opposition to the death penalty?
yeah, I will never agree with the death penalty.
Thank you very much for your time.
I have no question. All right, sir. Thank you. Your jury service is complete for the year. You're excused, and you may go enjoy your trip.
Okay.
Thank you. Yes, sir.
I just have connections with the department, police officers, the referencing, so I
Okay.
don't know if that needed to be mentioned.
You're excused. You're good. Thank you.
Thanks.
That's what I make sure you do on your trip.
Yep.
All right. So just for the record, I don't know if y'all could hear. He just said he had connections with the police department. Didn't know if we needed to know that. But explained to him he was excused. So unless you want him back to question him more, no.
That's okay.
444.
Thank you for the opportunity. I have to retell my tie to the truth. With my belly. Eyes the short hole, calling the kettle. When I thought the time, but the back party, that Lord, renowned. Pure and true. Well, I can't tell when I'm driving down the road, not dying my die alone.
All right. Please have a seat. Are you juror 444?
I am.
All right. I'll allow the attorneys to begin their question.
Good morning. How are you today?
Good, thank you.
I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Had you heard anything about this case or seen anything on the news prior to
I did see a brief clip on the news just the other day, and I did recall at that point what had happened back then, but I have really no knowledge of it.
Okay. The state will have the burden to prove the charges beyond a reasonable doubt, and we'll do that by calling witnesses, presenting evidence. There will be physical evidence, photographs, different types of things for you to consider in your deliberations. The only evidence that can be considered is what comes into court. Obviously, the news may not have everything right. There may be things you've heard that you're not going to hear in court. Would you be able to set anything you've heard aside and just base the verdict solely on what you hear here in court today?
Yes, indeed.
Now, as far as your availability for the next 2 to 3 weeks, obviously that's a big ask for someone to come in for that long. Do you have anything planned over the next 2 to 3 weeks that will cause extreme hardship for you to sit here on this jury?
No.
Now, moving on to the death penalty. As you heard this morning, this is a case where the state has elected to seek death. It is a rare situation where the state is even able to do that. The law requires certain aggravating factors to be met in order to seek the death. And so once the state proves at least one of those aggravating factors beyond a reasonable doubt, it will be up to the jurors to decide whether to recommend death or recommend life. Do you have any personal or moral or religious opposition to the death penalty?
I oppose the death penalty.
Okay.
I mean, that's just my general feeling on it. I've never been confronted to make a decision about it, but I just don't think anyone has a right to take a life.
And based on that, would you be unable to be fair and impartial in this case?
No, I don't think so. I think I would be fair. Again, I feel what I feel about it.
Sure.
Yeah.
So let me ask it this way. Obviously, you don't think there's a circumstance where the death penalty is appropriate. Is that accurate?
I hadn't really thought about it.
Okay. So would you say there are times when perhaps you would be able to recommend the death penalty?
I don't know that.
Okay, so and what we're looking for is we want people that are able to sit and listen to all the evidence. So what will happen is if the defendant is convicted of at least one count of first-degree murder, then the jurors will have to listen to the aggravating factors that the state presents, and then the defense will be allowed to present mitigation. And at the end of that, you will have, as an individual juror, to make a recommendation of either death or of life. And you'll have to sign your name to that saying, I believe this person should be put to death, or I believe this person should be put to life, based on your strong feelings that no one should receive the death penalty or that it's not appropriate. Do you believe that you could be a fair and impartial juror in this case because of your feelings on the death penalty?
I think I'm an incredibly fair and impartial person
Sure.
per se. So I assume that I am.
Okay.
Okay.
And I'm not saying you're not fair and impartial. Obviously, we want people that are fair and impartial to decide whether the state proves the charges beyond a reasonable doubt. The difference in this type of case is because it is a death penalty case, we need people that are able to consider the evidence and to be able to recommend death if appropriate. And there's some people that just cannot because of their beliefs in the death penalty. And so that's why we bring you all in individually to ask your specific beliefs on the death penalty.
I don't have a religious moral conviction about it. I just don't think it's the right thing to do.
Okay, thank you.
Shirley?
Morning.
Hi.
My name's Kevin Shirley. That's Lee Hollander, and we're happy to represent Mr. Wilson in this case. I just want to clarify. It's the state of Florida allows death as a possible penalty in those worst of the worst homicide cases. Do you understand?
Yes.
And if you weren't reluctant to recommend that as a possible sentence, there might be something wrong with you. So it sounds like you're reluctant. But if you're an individual that says, under no circumstances can I ever recommend death as a possible penalty, then this isn't the case for you to try. Do you understand?
I do.
The judge is going to instruct you that death is a possible penalty. We both told you that death is a possible penalty. You would just have to determine whether or not it rises to that level, whether or not it's the worst of the worst cases, and whether the state has proven aggravating factors. Do you understand?
I do.
So let me just run through the scenario and then I'll ask you the bottom line question. If you're selected as a juror, for purposes of our discussion here this morning, we kind of have to assume the state has already met its burden and the jury has returned a verdict of guilty as to at least one count of first-degree murder, okay? That's not true yet because
I understand.
there hasn't been any evidence, but for our discussion this morning. Now, so then we move to the penalty phase, and as you've been told a couple of times, the state has to prove aggravating factors beyond every reasonable doubt, the same burden of proof they had in the beginning stages of the case, which is a very high burden. That's why it's the worst of the worst is they have to prove these aggravating factors. Do you understand?
Yes.
Now, they have to prove at least one aggravating factor to the satisfaction of all 12 jurors, or if they don't, then the jury has to recommend as a whole that our client be sentenced to life in prison. Do you understand?
Yes, I do.
If the jury unanimously finds at least one aggravator, then you move to the next stage where you're allowed to entertain mitigating circumstances. Now, they're not mitigating factors because the burden of proof is not beyond every reasonable doubt. It's the greater weight of the evidence, which is a much lower burden of proof. That's the burden of proof that would be on us if we elect to show you mitigating circumstances. Okay?
I got it.
All right. Now, with aggravating factors, the judge is going to tell you what they are, and there's not a lot of them. That's what makes this kind of case an unusual case, is because there aren't very many. So if they don't qualify, then he gets life. Do you understand?
Yes.
But with mitigating circumstances, the judge may give you a list, but you're not confined to that list. There may be something else that you heard, something during the trial, something that came out of the mouth of one of our witnesses, something about Mr. Wilson's childhood, his background, his mental health, all kinds of different
Sure.
things you can consider mitigating circumstance. And then you have to decide in your own mind whether or not the aggravating factors outweigh the mitigating circumstances. And if they do as a jury, then you move on to the final step where you vote as to what recommendation you're going to send as a jury to the judge. And in the state of Florida, if 8 jurors find the aggravators outweigh the mitigators, and they don't have any doubt in their own mind that that's the appropriate sentence, if there are 8 folks, then they have to recommend death. Anything less than 8, the jury recommends life. What we're trying to find out is, even though you have this internal process going on right now, whether or not you can follow those procedures and consider death as a possible recommendation to the judge. If you can't do that under any circumstances, this may not be the case for you. If you can, and you can follow the judge's instruction, maybe you can sit on this jury panel. So why don't you tell us how you feel?
It's a very difficult question because I do morally believe in my heart that nobody has the right to take another's life. But I also can understand that what the law is. The law is saying this is the way we treat people who do this. So, I don't know. Quite frankly, I'm being honest with you. I simply don't know how I would rule on that.
Okay, that's an honest answer. Thank you very much.
All right.
Do you want her to go?
Yeah, we'll have you go back to the waiting room, and we'll call you back in just a minute.
Where am I going?
The bailiff will show you.
Okay.
All right, let the record reflect that juror 444 has left the courtroom.
The state moves her cause, Your Honor. There is a reasonable doubt that she can be fair and impartial. She's made several comments. First of all, she said she's opposed to the death penalty right off the bat. Then she said she doesn't have a conviction, a religious or moral conviction. She said she doesn't think it's the right thing to do. She also said nobody has the right to take another life. So although Mr. Shirley talked about all the procedure and process and went over that with her, it is very clear from the answer she gave that she does not believe in the death penalty, that she doesn't think that a life should be taken. And given the actual words that came out of her mouth, she cannot be fair and impartial. There is a reasonable doubt as to whether this juror can be fair and impartial. So I'd ask that she be given.
I think she is. I think she is in a dilemma because she understands that that's the law in the state of Florida, and would follow the law in the state of Florida. She just her morals are tugging at her as to her ability to rise to that level to send a recommendation, which honestly, most of these people should have the same struggle. They're just not verbalizing it. But we do not believe that it meets the burden for to be stricken for cause and
Okay.
defer to the court.
All right, and I've taken careful notes and listened to what she said. I'm going to deny the state's request to strike her for cause, and we can have her come back tomorrow morning at 9 a.m. We'll bring her in. Let me just tell her. All right. Juror 444. All right. So if you remember my earlier instructions about not looking up anything, doing anything, we're all standing up for you. It's okay. Not looking up anything or doing anything in terms of watching news media, reading newspapers, discussing anything about this case. You can follow all those instructions?
Yes.
All right. Please come back here tomorrow morning at 9 a.m. and it'll be in the jury room on the second floor. You're coming back tomorrow. We're going to have further jury selection tomorrow. Okay. All right. All right. So juror 4.
Your entry.
All right. Please have a seat.
Thank you.
All right. Good morning. Are you juror 4?
Yes, Your Honor.
All right. Then I'll have the attorneys begin their inquiry.
Good morning. How are you?
Good, thank you.
My name's Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state. Prior to coming in this morning, had you heard anything about this case?
I have
And where have you heard information?
from my friend yesterday through text message.
And was it just your friend saw something on the news or related to the case?
Yes, ma'am.
Now, based on what your friend told you, have you already made up your mind about the defendant's guilt in this case?
Yes, ma'am.
Right. So would you be able to set that aside, or you already know?
I cannot put it aside because of religious reasons, so it wouldn't be fair.
All right. Thank you.
Thank you.
That's fine. I have no question.
All right. Thank you. Your jury service for the year is complete. You are excused.
Thank you.
Let me just go back to, I want to make sure. So just to make sure, juror 230, 476. And now juror 4, any objections to them being stricken for cause?
No.
No.
Okay, very good. Now we're ready for juror 492.
Move right along. We'll get 20 done this morning. If I lose 15, we'll get up to 50. So far, we only got 2. About 5. Your entry.
All right. Please be seated. Are you juror 492?
Yes, I am.
All right. I'll allow the attorneys to begin their inquiry.
Good morning. I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state. Prior to coming in this morning, had you heard anything about this case?
No, I have not.
Now, as far as the length of the trial, we anticipate it to be probably another 2 weeks. Do you have anything that would cause extreme hardship for you to sit on this case?
So my job is a commission-based job. So if I'm not on the phone at my job, I'm not making any money. So
Would the fact that you are unable to make money for 2 to 3 weeks, would that cause extreme financial hardship where you may not be able to pay bills or?
it could, but I don't think I would be able to compensate for that over the next couple months.
So based on that, would you have a hard time sitting and listening to the evidence knowing that you were not making money?
No.
You would still be able to sit and listen either way? Okay. Now, as far as the death penalty is concerned,
Sure.
you heard that this case, that the state has elected to seek the death penalty. Do you have any personal or moral or religious opposition to the death penalty?
To the death penalty itself now.
Now, a lot of people have strong feelings. Some people haven't really thought about it. There's people that I would say are on one end of the spectrum that think if it's first-degree murder, the person should get the death penalty automatically. And then there's other people that would say no one should ever get the death penalty, regardless of who they kill, the circumstances, a number of people, they should never get it. And then there's people that are more in the middle that would say just because someone's charged with first degree murder doesn't necessarily mean they should get the death penalty, that we should consider the factors, consider the evidence, and it should really be based on a case by case basis. Where would you say you fall on that spectrum?
What I would like to say is that I am a survivor of domestic violence.
Okay.
And I have very strong opinions about violence against other people, especially when they are defenseless. And I just want to make sure that you are aware of that and that emotions may be a factor
All right.
in my decision.
I am going to ask you about that if that's okay.
Sure.
In this case, we are alleging that 3 women were victims. 2 were murdered and 1 was battered. Based on just hearing that limited information, do you think your own life experiences could potentially get in the way of you being able to be fair and impartial on this type of case, given the allegations?
I would say that is the case, yeah.
Thank you very much. I appreciate you bringing that up.
I have no question, Your Honor. Thank you.
All right. Thank you for your service. Your jury service for the year is complete. You are excused. Then I will let the attorneys begin their inquiries.
Good morning.
Good morning.
How are you today?
Hanging in there.
A little bit difficult to be here, I know. My name's Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state. Prior to coming in for your jury service, did you hear anything about this case?
No.
Now, as far as the length of the trial, we anticipate after this week, it'll be another 2 weeks. Do you have any extreme hardship that would cause you to be unable to sit for the next 2 weeks on a jury?
This is my situation and I'm not making excuses,
Sure.
but last week, Monday, my significant other, we've been together 31 years, injured himself at work. Took him to the hospital Wednesday. He's at Gulf Coast Medical Center right now as we speak. Ended up with health conditions galore. So I am his healthcare surrogate / POA. So I've been in the hospital every day with him, and they're trying to convert him from IV medications to oral medications to get him home, and I'm going to be his primary caretaker. So that is my issue.
All right. And would that be cause of distraction, obviously?
I think it would, because I can't sleep. I'm tossing and turning. He's calling me at night because of the pain. So it's like, and by the time I remembered to bring this in, it was just like, oh my God, it's time for me to call. So that's my issue that I have going on home.
Of course. And thank you for sharing that. And I'm really sorry to hear that. It sounds like a difficult issue.
It
and
is.
probably not good timing in your life to be
Right.
sitting on this case. Thank you
Right.
very much.
I have no question.
All right. All right. Well, your jury service for the year is complete. You are excused.
Thank you.
And I wish your significant other better.
Thank
better
you. I
health.
appreciate it.
All right. Any objection to 303, strict for cause? All right. 228.
Yeah. Except for you. I'm a disaster. I gotta give it to you. Sure entrance.
All right. Good morning. Please be seated. Are you juror 228?
Yes, I am.
Then I will let the attorneys begin their inquiry.
Good morning.
Good morning.
I'm Sarah Miller, and this is Andreas Gardner. We're here on behalf of the state. Prior to coming in this morning, had you heard anything about this case?
I have.
How much have you heard about it?
Not a lot.
Now, the state has the burden to prove the charges beyond a reasonable doubt, and we can only do that with evidence that comes through this courtroom. Would you be able to set aside anything you may have heard on the news and decide this case solely based on the evidence from this courtroom?
I'm not sure I could be totally impartial. And I'll just jump right into it.
Please do.
I had somebody steal my car.
Okay.
And then after they stole my car, they kept the house keys. And then they came in and out for the next month. So, victim of a home invasion, I just don't think I could really be unbiased and say, put my history and the information I've had
Thank you very much.
aside. I'm not sure I could do it.
And you heard the charges. There's a grand theft auto.
I do.
As
I
well as
heard
a
that.
burglary. So thank you for bringing that up.
Mhm.
And I appreciate your time.
Okay.
I have no questions.
All right. Your jury service for the year is complete and you are excused.
Thank you.
You're welcome.
Oh, that's here. Friday.
Any objection to juror 228 being stricken for cause?
No.
No, Judge.
All right. 30, I'm sorry, 52.
Roll here. Your entrance.
All right. Please be seated. Are you juror 52?
Yes, sir.
All right. I'll let the attorneys begin their inquiry.
Good morning. How are you?
Good, how are you?
Good. Prior to coming in this morning, had you heard anything about this case?
No, ma'am.
Right now, you heard that this trial is going to be for the next 2 to 3 weeks, probably more like 2 at this point.
Yes, ma'am.
Do you have anything that's would cause extreme hardship for you to sit here on a jury?
Just a little bit of financial hardship. I work flat rate service hours, so I mean, other than that, I wouldn't really have anything else going on or hardships.
All right. The fact that you may not be able to work for the next couple weeks, would that cause you to not be able to pay your bills or get evicted?
Yes, it would.
It would. Okay. The fact that you may not be able to pay your bills, would that cause you difficulty sitting here and paying attention to the case?
No, it wouldn't.
Okay, so you're still willing to serve even if you might have to miss a
Yes,
couple
ma'am.
weeks.
Yeah.
All right. Well, thank you for that service. We really appreciate it. Now, do you have any personal or moral or religious opposition to the death penalty?
No, ma'am.
So a lot of times you meet people that have very strong views on the death penalty one way or the other. And then there's some people that just are sort of neutral. You have some people on one end that might say anybody charged with first-degree murder should get the death penalty, no matter what, no matter the circumstances. And you have people on the other side that would say no one should ever get the death penalty, regardless of how many people they kill, the facts, how egregious it is. And then you have the people in the middle that would say, I have to hear what the facts are, what the circumstances are before I'd be willing to decide whether someone deserves death or life.
That's where I'm at.
That's where
I'd have to hear it. I would have to hear and see. Yeah.
And that's really what we're asking, is that you'd be able to listen to everything. And so the first phase of the trial we'll have is the guilt phase. And during that phase, we'll have to prove the charges beyond a reasonable doubt. If we do prove at least one count of first-degree murder, then you'll go on to the penalty phase. And at that penalty phase, the state will present aggravators. And those are all laid out by statute. We can't just make them up or decide on our own that it's a death penalty case. We have to meet certain requirements. If you find as the jury that we have proven at least one of those aggravators beyond a reasonable doubt, you can also then consider mitigating circumstances. And that's where the defense can present, if they choose to, circumstances as to why their client should not get the death penalty. Do you believe, after hearing all that if you felt the facts did rise to a level where death was appropriate, that you would be able to make that recommendation of death?
Yes, ma'am.
And do you feel that if they didn't rise to that level, that it was just a case where you felt like this really isn't deserving of death, you'd be able to make a
Oh,
recommendation?
most definitely, yeah.
And you
Yeah.
seem like someone also that if there was a tie and you were the tiebreaker as to whether there was a recommendation of death, would you be able to stick to what you believe and what you think about?
100%.
All right.
Yeah.
Thank you very much.
All right, Mr. Shirley.
Morning.
Yes, sir.
My name's Kevin Shirley. Sitting next to me is Lee Hollander, and we are happy and proud to represent Mr. Wade Wilson. Okay?
Yes, sir.
You understand, I picked up on it already. If somebody's convicted of first-degree murder in the state of Florida, there's two possible penalties. One is death penalty, obviously, because that's why we're asking questions about it. The other is life in prison. Is that yes?
Yes, sir. Sorry.
Because there's a microphone there. You have, sir. Okay. The state of Florida doesn't have parole anymore. We used to have parole. If you were good in prison, you didn't get a disciplinary report, you advanced your education, whatever, you could get out early. You understand that?
Yes, sir.
We don't have that anymore.
Yes, sir.
So if you recommend life, he's in there for the rest of his natural life. Do you understand?
Yes, sir.
Never coming out again.
Yes, sir.
You think that's a pretty serious penalty in and of itself?
I mean, that's pretty serious. It's as serious as it gets. I mean, other than obviously death.
All right. I just want to make sure you can follow the procedures. Sounds to me like you can. I just want to make sure if you're selected as a juror, the judge would give you some aggravating factors that you could consider. That list isn't, it's not a long list because aggravating factors are only relevant to the death penalty. So you understand the death penalty is not to be taken lightly. It's only for those exceptional cases. It's not for every homicide case. Do you understand?
Yes, sir.
So the judge would give you what the aggravating factors were you could consider. You can't consider any other factors, just the aggravating factors, whether it's 1, 2, 3, 4, whatever it is. Do you understand?
Yes, sir.
And then the state has to meet their burden of proof. It's the same burden of proof they had initially in order to convict Mr. Wilson. That burden of proof does not go down. It stays right where it's at, and they have to prove aggravating factors beyond every reasonable doubt. Do you understand?
Yes, sir.
Now, if you're a juror, you're going to listen to the instructions, and you're going to go back and you're going to vote as a panel, the entire jury as a whole, as to whether or not the state has proven to each and every juror whether or not there is an aggravating factor. If one or two or however many say, no, I'm not convinced they've proven an aggravating factor, it's not unanimous, and so therefore you have to return a recommendation of life. Do you understand?
Yes, sir.
If you do determine unanimously that they've proven it, then you move on to the next stage, as the state has alluded to, and you have to entertain mitigating circumstances. They're not mitigating factors because they don't have to be proven beyond a reasonable doubt. The burden of proof is much lower. It's the greater weight of the evidence. Do you understand?
Yes, sir.
Okay. In that, you can consider, the judge may give you a list of things you can consider as mitigating circumstances, but you're not confined to that list like you are with the state with aggravating factors. You can sit there and review in your own mind evidence that you've heard during the course of the trial. Something you heard during the trial could have been a mitigating circumstance. Something that we bring to your attention when it comes to our turn in the case may be a mitigating circumstance. It might have something to do with Mr. Wilson's childhood, relatives, Mr. Wilson's mental health, anything like that you can consider as a mitigating circumstance. You understand?
Yes, sir.
Then you have to do a weighing process to determine whether mitigating circumstances outweigh the aggravating factors. If they do, then you have to return a recommendation of life. You understand?
Yes, sir.
If the aggravating factors outweigh the mitigating circumstances, that's not the end of it. Then you have to do a little bit of soul searching, and you have to determine in your own mind as an individual what recommendation you would give to the court as far as a sentence goes. And then you go back knowing that and vote as a panel again. And in the state of Florida, it takes 8 jurors to recommend death. Do you understand that?
Yes, sir.
And like the prosecutor alluded to, if you're the one on the fence, there's 7 that say death and 4 that say life, and your vote carries the day. Are you that guy that can carry the day?
Could be.
All right.
Yeah. If needed.
Yes, sir. I don't have any further questions. Thank you.
All right, sir. Remember my earlier instructions. Don't do any research, look up anything, discuss anything about this case with anyone. Do not watch local news broadcasts or read any local newspapers. And we'll have you come back here and you can follow all those instructions, right?
Yes, sir.
All right. Then come back here tomorrow morning at 9 a.m. to the jury room on the second floor.
Yes, sir.
And the bailiff will escort you out. All right, please be seated. Good morning. Are you juror 302? All right, I'll allow the attorneys to begin their inquiry.
Morning. So are you the last one in the juror room? Okay.
Yes.
We do it by number, so no, we don't rank it or anything.
Right.
Thank you for being here and for your time. Again, I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in today, had you heard anything about this case?
Yes.
And where did you hear information?
News and whatnot around
Okay. Have you heard it just in the last weeks or from when this case?
when it first started and recently that they were selecting.
All right. Now, the state is obligated to prove the charges beyond a reasonable doubt with only evidence that comes out in this courtroom. Obviously, what is said on the news, what's told or reported on may or may not be accurate. It may or may not be relevant information for this trial. Would you be able to put aside anything you may have heard or learned about the case and base your verdict solely on what you would hear in this courtroom?
Honestly, I don't believe I could.
Thank you very much.
I have no question, Your Honor. Thank you.
All right, your jury service for the year is complete and you are excused.
Thank you.
Thank you. Okay. All right, any objection to 302 stricken for cause?
No.
Okay. All right, please be seated. Do we have another 10? Oh, okay. Yes. Yep. So the next person would be 11. Okay.
That's the take on the okay, so it really just depends. Oh yeah, because you're saying. No, it's brown in our yard, or none of us that teach you. No. We should ensure you be so careful. I watched it parking lot yesterday when I went to his car just to be that. You have to be for sure.
And we'll let the attorneys begin their questioning.
Good morning.
Hi.
How are you today?
Good, how are you?
Good, thank you. I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming here today for your jury service, had you heard anything about this case?
Not at all.
Now, we anticipate that the trial will last another 2 weeks beyond this week. Do you have any extreme hardships or issues that would cause you to be unable to sit on a jury?
Not at all.
And do you have any personal or moral or religious opposition to the death penalty?
Not necessarily. I'm not super familiar with it, but not necessarily.
Okay, so let me ask this way. There's often a spectrum of people with regards to their views on the death penalty. And it sounds like it's probably not something you've thought a lot about or talked a lot about. There's some people that would say anytime someone is charged with first-degree murder, they should get death, no matter what the circumstances are. Then you have other people on the opposite end that would say the death penalty should never be given. We shouldn't have it. It doesn't matter who you killed, how many people you killed, what the facts are. It should be illegal. And then in the middle of that are people that would say it really is a case-by-case basis. And I would have to hear the evidence and hear the facts to really make that decision. Where would you say on that spectrum you believe you would fall?
I'd say I'm probably like right around the middle, maybe more leaning like toward that if it's like if the individual is guilty, that they probably should get that.
Okay. And what we would ask is that that just because someone's charged with first-degree murder, would you automatically say they deserve the death penalty, or you would still be willing to listen to the evidence?
I'd definitely still be willing to listen to the evidence.
And for the charge of first-degree murder in the state of Florida, the state can elect to seek the death penalty, but only in certain cases. And the statute's very clear about what those cases are, what the aggravators are, and it's very limited when the state can seek it. So in this case, the state has listed out those aggravators. You'll hear more about that as we go on. And I know this morning was a lot of instructions and words you've probably not, heard in your normal everyday life. So the judge will continue to explain the process as we go on. In the first phase, in the guilt phase, is where it will be the state's burden to prove the charges that we've alleged. And you heard those 6 charges read this morning. You'll be read those again. The state will prove those beyond a reasonable doubt. And then if you and all the other jurors find that we proved at least one count of first-degree murder, then you'll go on to the penalty phase. And at that penalty phase is where you'll learn about the aggravating factors the state is alleging. And you'll have to find again, as a jury, unanimously, that we've proven at least one of those aggravating factors. The defense has the opportunity to present mitigating circumstances, reasons that they believe their client should not be put to death. You'll listen to all of that. You can think about the things you heard in the trial, and you can consider whether you believe you would recommend death or whether you'd recommend life. Do you believe that if you felt that the facts that you heard and the circumstances that you heard about, if you felt that it rose to the level of death, would you feel comfortable making that recommendation to the court, saying, I believe that this defendant should get the death penalty?
Yes.
And then on the flip side, if you listened to everything and you felt like, I just don't think there's enough here, or that I think there's things that would mitigate that the defendant should not get the death penalty, would you be comfortable recommending a life sentence?
Absolutely.
All right. And this is obviously a big task. It's something that most people have never done and never will do. Do you think you're up for the task to sit here and listen and to make a recommendation?
Absolutely. I'd be grateful for the opportunity.
All right. Thank you very much.
Thank you.
Oh, wait 1 second. I'm going to let
The
Mr. Shirley
defense
answer
has
the
to
question.
answer.
Morning.
Hi.
My name's Kevin Shirley. My co-counsel Lee Hollander, and we're proud to represent Mr. Wilson here today. Let me just ask you a few questions. Some are going to sound similar to what the state said, but they're a little bit different. Obviously, it's come to your attention that if somebody's convicted of first-degree murder in the state of Florida, there's 2 possible penalties. One of those penalties is life in prison. Do you understand that? We have a microphone right
Yes, sorry.
there. In addition, the state of Florida used to have a thing called parole. So if you conducted yourself appropriately and did certain things, they would consider letting you out early. Well, they don't have parole anymore. So if you recommend life in prison, that's exactly what Mr. Wilson would get. He would get life every day of the rest of his life in prison. Do you understand?
Yes.
Yes, he'd never get out again. You understand?
Yes.
Okay. Do you think that's a very serious penalty?
Absolutely.
The as the state has alluded to, the death penalty, it has to be saved for those very exceptional cases of homicide. Do you agree with me?
Yes.
I mean, it's not. I heard something earlier from you that said you would be leaning toward, and I'm not sure what you mean. You'd be leaning toward. As you sit there now, would you give a preference to the death penalty over life in prison just because the state proves there's a first-degree murder?
I think it would depend on all the evidence that I would hear, but
Okay.
I probably sit right in the middle.
All right. Because it's an exceptional type of case, the state, there are aggravating factors that are involved. It's a very small list of things that the state can prove in order to try and convince you that death is the appropriate penalty. It's not an unlimited number of things. There are very few things, and the judge would instruct you on what those things are. Do you understand? And you couldn't consider anything outside that as an aggravating factor. You're just confined to those. Would you agree to follow that instruction?
Yes.
And the burden of proof on the state to prove Mr. Wilson guilty of the charge of first-degree murder is beyond every reasonable doubt. You understand that?
Yes.
Well, that burden carries on to the penalty phase. So if they convict him of first-degree murder, then in the penalty phase, they have to prove aggravating factors, and they have to prove them beyond every reasonable doubt. Do you understand that?
Yes.
And they have to prove them beyond every reasonable doubt, not just to you, but to all 12 jurors on the panel before you can even go on to the next step. Do you understand that?
Yes.
So if they don't prove it to everybody's satisfaction, at that point in time, your recommendation is for life because it's not unanimous. You understand?
Yes.
Okay. You're going to get instructions on this later. I'm throwing a lot of stuff at you here. But then you move on to the next phase. And the state alluded to it. There are mitigating circumstances that you can consider. And we don't have to prove those circumstances beyond every reasonable doubt. It's just by the greater weight of the evidence. You understand?
Yes.
Yes.
Sorry.
It's okay. That's natural.
Yeah.
Now, the judge may give you a list of mitigating circumstances, but unlike the aggravating factors, you're not confined to that list of mitigating circumstances. There's all kinds of things you can consider that aren't necessarily on that list. There might be something that you heard during the trial that you would consider a mitigating circumstance. We may bring forward some evidence that you could consider as mitigating circumstance, such as something in Mr. Wilson's childhood. Do you understand?
Yes.
Mental health mitigation. There might be experts to testify. You could take that into consideration. Could you do that?
Yes, absolutely.
All right. And then once you've heard all that, you're going to weigh the mitigating circumstance against the aggravating factors. If the mitigating circumstances have more weight to them than the aggravating factors do, then you return a recommendation of life because those aggravating factors have been mitigated. Do you understand that?
Yes.
All right. If the aggravating factors carry more weight in your mind than mitigating circumstances, that's when you jurors vote as an entire panel as to what recommendation you're going to send to the judge. And that's when you as a jury have to have an 8-4 vote to send it to the judge to recommend death. Do you understand? It's not a simple majority. It's 8-4. Yes? Okay. And I think one of the things the state was alluding to also was, let's say it's 7-4. Okay. It's real close. And you're that last one. If you are not convinced that death is the only appropriate penalty, Are you going to be swayed by the other jurors, or can you stand your ground?
I can stand my ground.
That's all I needed to hear. Thank you.
Okay.
All right. So remember my instructions. Don't look up anything on the internet or anywhere else. Don't watch local television or read local newspapers. Don't discuss anything about this case with anyone. Do you understand those instructions?
Yes, I do.
All right. Well, please follow those instructions and come back here tomorrow morning, Thursday morning at 9 a.m. back to the jury room on the second floor. Thank you.
Door entry.
Yes, right behind the microphone. Please be seated. All right. Are you juror 343?
Yes, sir.
All right. Then I'll let the state begin their questioning.
Good morning.
Good morning.
I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state. Did you know anything about this case prior to coming in today?
No.
Now, you heard the judge talk about the length of the trial. We anticipate another 2 weeks after this week. Do you have any extreme hardships that would cause you to not be able to sit for the next 2 weeks?
No.
Now, as far as the death penalty is concerned, do you have any personal or moral or religious opposition to the death penalty?
I do not.
Now, people often fall on a spectrum. There are some people that would say if the state charges first-degree murder, they should automatically get the death penalty, no matter what the circumstances, no matter what the facts. Then there's other people that would say that no one should ever get the death penalty. It doesn't matter who they killed, how many people they killed, the method they used, it should never be allowed. Then we have people that are more in the middle that would say it really should be a case-by-case basis, and I would take and listen to whatever the facts are and what's presented and make a decision based on what I hear. Where would you say you fall on that?
In the middle.
Now, at the original or at the first part of the trial, it'll be the guilt phase where the state has to prove the charges beyond a reasonable doubt. And we'll have to present witnesses and evidence, just like any other trial you might see on TV. When that case is over, the jury will retire and have to reach a verdict. And if you all decide unanimously that we've proven at least one count of first-degree murder, then you'll go on to that penalty phase. And at the penalty phase, the state will have to prove at least one aggravator. So again, the state of Florida doesn't allow every first-degree murder to automatically have the death penalty. There are certain factors that we have to meet, that we have to be able to show and to prove. So we've alleged various factors in this case that you'll learn more about. But if you agree with the other jurors that we have proven at least one of those aggravating factors, it will be up to you individually to make a recommendation of life or death. And at least 8 of you will be needed to make a recommendation of death. Now, if you get back there and you've listened to all the evidence and you feel like the state has met its burden, you feel like the facts you've heard, the circumstances would rise to the level of a death penalty sentence, do you feel comfortable that you'd be able to sign your name and make that recommendation? And then on the flip side, if you feel, and the defense also at this hearing gets to make, they can present mitigating circumstances as to why their client shouldn't get that. Do you believe if you hear the information at the penalty phase or through the trial and you just don't think it rises to the level of a death sentence, that you'd be able then to make a recommendation of life?
Yes.
Okay. How do you feel just sitting here knowing that this is a death penalty case? Do you have any strong feelings that come to mind, or just what are your thoughts right now?
I believe in justice and having all the facts presented and making a decision based on evidence.
So based on this being just a very serious case and a heavy responsibility, it's something you believe that you'll be up for, able to do.
Yes.
Thank you very much.
Mr.
Good morning.
My name is Kevin Shirley. My co-counsel is Lee Hollander, and we're here and pleased to represent Mr. Wilson. I'm looking at you from across the room. You look a little uncomfortable in the situation. You're sitting here, you got cameras pointing and people asking you questions. Do you think you're comfortable enough to be able to sit through a trial and listen to all the evidence and render a recommendation to the judge on a sentence?
I do. This is my first time ever doing this.
Okay. Well, that's understandable then. Yeah, we're giving you the worst of the worst right from the get-go. Sorry about that, but that's the luck of the draw. As you have been able to determine, there are only 2 possible sentences upon murder conviction, that being life in prison or the death penalty. You understand?
I do.
And in the state of Florida, life means life. We used to have parole in the state of Florida. We don't anymore, where people actually had the opportunity to get out a little early. Now, if you recommend that Mr. Wilson go to prison for life, he will spend every day of the rest of his life in prison. Do you understand that?
I do.
You think that's a very serious sanction for homicide?
Do.
You're a little hesitant.
Can you repeat the question, please?
Well, do you think that that's a very serious sanction? I mean, homicide is the worst of charges, okay?
Absolutely.
But do you think that life in prison is an appropriate sentence for homicide?
Given the facts and the evidence, I could make that decision.
Okay. You understand that the death penalty is only for the worst of the worst homicide cases. It's not to be judged lightly in every homicide case. It's like I said, it's the worst of the worst. You understand?
Do, sir.
The judge would give you a list of aggravating factors. You wouldn't be allowed to consider any other factors other than the ones that the judge gives you, and you'd have to make a determination as to whether or not the state had proven them beyond and to the exclusion of every reasonable doubt. Do you understand that?
I do.
If they have not, and they have not convinced all 12 jurors that they have met their burden of proof, then you have to recommend life at that point in time. Do you understand?
Absolutely.
If you get past that point, you go on to the next stage where you have to consider mitigating circumstances. Now, these circumstances aren't factors, so they don't have to be proven to you beyond every reasonable doubt. It's a lower burden of proof. Do you understand that?
I do.
And the judge may give you a list of mitigating circumstances, but you're not confined to that list of mitigating circumstances like you are with aggravators. You, in your own mind, can determine what would be a mitigating circumstance, what would tend to lessen the impact of the aggravating factors. And it may be something you heard during the trial, maybe something you hear from a witness. You might be able to consider things that happened to Mr. Wilson when he was a child that formulated the way he is. Some of it might be mental health evidence. Would you be able to consider mental health evidence as a mitigator?
Absolutely.
So then you go through a weighing process again to determine whether the mitigators outweigh the aggravators. If they do, and the aggravators have been sufficiently mitigated, then you have to return a recommendation of life again. You understand?
I do.
Now, if the aggravators outweigh the mitigators, then you have to go back and you have to vote as a jury as a whole as to what your recommendation is going to be to the judge. And in the state of Florida, it requires 8 jurors to recommend death as the penalty. In this particular case, if there are 7 voting for death and 4 for life, and you're the last one to vote, they want to hear what you have to say, but your vote carries the day. If you vote death, recommendation is death for the whole panel. If you vote life, then recommendation is for life. Do you think you can adhere to your beliefs and your opinions about the case, what you've heard, and most of all, your feelings about what the appropriate penalty should be?
I do.
I don't have any further questions. No objection?
All right. So you remember my earlier instructions about not doing any research, looking up anything, or discussing anything about this case with anyone. Okay. So please follow those instructions. Obviously, don't watch any local news media, read any local newspapers or anything like that. And just be back here tomorrow morning at 9 a.m. in the second floor jury room. Report back there at 9 a.m. tomorrow morning.
Thank you, sir.